Imagine just waking up tomorrow, getting your coffee, starting your day, and suddenly your children are gone.
Just completely gone.
Yeah, exactly. And there was no trial. There was no jury of your peers. I mean, there wasn't even a day in court where you got to defend yourself. There is just like a single piece of paper, often based on an entirely anonymous phone call, and your kids are simply removed.
Right.
And if you want to even begin fighting to get them back, well, you are going to need, on average, over $61,000 just to start the conversation.
Which, I mean, it sounds like a dystopian novel. It sounds like something happening in a fundamentally broken authoritarian state.
Yeah.
But the reality is this is a procedural norm happening in every single zip code across the United States.
It's terrifying. And today, for you listening, we are going to pull the curtain back on exactly how that happens. Welcome to the deep dive. We have a massive stack of source material sitting right on the table in front of us, and it is entirely focused on a 50-state intelligence briefing. It's titled Stand With Meg, National Family Court Crisis Briefing.
And we should probably clarify right away that, intelligence briefing is not a metaphor here.
Right.
It is genuinely the only accurate operational way to describe the documentation we are looking at today.
Okay, let's unpack this, because the sheer volume of what we have received is, frankly, staggering. We are looking at a highly comprehensive slide deck. We have a raw, incredibly detailed survey data report representing exactly 1,953 families.
Yeah, almost 2,000 families.
And we have visual evidence, too, like campaign posters, photographs of a woman named Meg testifying at a legal podium. And our mission for this deep dive is to explore this documented systemic crisis currently unfolding in family courts and Child Protective Services, or CPS, across the country.
Right, the whole system.
But the angle here, the thing that makes this completely unprecedented, the thing you have to keep in mind for the duration of this conversation, is how one single mother, Meg, spearheaded this massive data collection effort entirely on her own.
Which is just incredible.
She did this by herself, to help thousands of others. And we are going to comb through the absolute mountain of data she has gathered.
It is the scale, really, and the methodology of it that immediately stands out from an analytical perspective. When you typically hear about family court disputes, it is very easy for the legal system, or, even the general public, to just dismiss them as isolated incidents.
Oh, for sure. It's just a messy divorce.
Exactly. We write them off as high-conflict individuals, bitter divorces, or, he said, she said scenarios. But what Meg has compiled here isn't just a collection of personal grievances. It is a quantified, mathematically backed documentation of systemic failure across the United States.
It's actual data.
It's hard data.
Yeah.
It is undeniable metrics.
Right. It's like trying to play a board game where your opponent is allowed to change the rules on every single turn.
And the referee's being paid by your opponent.
Yes. And until now, nobody outside the game believed you when you told them it was rigged. But Meg just recorded the entire game and published the rule book for everyone to see. And the spark for all of this, the catalyst, is Meg herself.
Right.
Let's talk about the visual evidence we have of her, because it really sets the emotional and, the logistical tone for everything we are about to discuss.
The visual framing is crucial here.
It really is. There is this campaign poster included in the sources. Meg is positioned right in front of this weathered, vintage-looking American flag. She's looking directly at the camera, and it is a fierce, entirely unyielding expression.
Very determined.
And right next to her, in this bold crimson and white text, it reads, "Stand with Meg, the fight for America's families."
Notice the language there, too.
Yeah.
It frames the issue not as a localized personal squabble, but as a national constitutional crisis. She is elevating a localized trauma into a national dialogue.
Exactly. And the quote from her on this poster just hits you right in the chest. I want to read it directly to you so you can feel the gravity of the stakes here. She says, "They took my kids. They tried to silence me. They won't."
What's fascinating here is how that raw personal defiance translated into highly sophisticated logistical action. If we look at Meg's personal testimony from the data report, we get the context of that quote.
Right.
Meg is a mother from Kansas. According to the data she provided, her 5 children were removed on January 29, 2024. And the defining, terrifying characteristic of this removal, there was no trial.
None.
There was zero due process.
5 kids just gone. Poof, overnight.
Yes. And her testimony explicitly states that the system kept the separation going through deliberate bureaucratic delays, severe visitation restrictions, and outright retaliation. Now, psychologically, most human beings would completely collapse under that weight. I mean, you are fighting the unlimited resources of the state for your own flesh and blood.
It would break anyone.
But instead of simply drowning in what has to be unimaginable personal trauma, she channeled that nightmare into a meticulously organized national data-gathering operation. She didn't just hire a lawyer to fight her own localized case.
Right, she went so much bigger.
She built an entire digital platform, standwithmeg.com, to capture the metrics of a fundamentally broken system.
Which brings us to these other photographs we have of her. We have these images of Meg at a legal podium, actively testifying. She's wearing a sharp, light blue suit with a white ruffled shirt.
Very professional.
Yeah, she's got a microphone in front of her, stacks of papers in her hand, and she's gesturing passionately. She looks incredibly composed, but you can see the absolute fight in her eyes. And behind her, sitting in the gallery on these wooden benches, are other women watching her, supporting her.
It's a powerful image.
It's this profound visual of a woman who has just stepped into the arena. And I keep coming back to the fact that she did this by herself. She turned her personal, agonizing nightmare into an intelligence package that gives a voice to nearly 2,000 families. It's unbelievable.
It is a massive undertaking.
But I do have to push back a little here, or at least, ask the question that I know you listening are probably thinking. It's incredible that one person could compile all this. But when you look at these numbers, how does an individual even begin to quantify a crisis that spans 50 entirely different state jurisdictions?
That's the million-dollar question.
Right. Because family law is notoriously localized. Every state, sometimes every single county, has its own bizarre set of rules, its own local precedents, its own judges. How do you map that chaos?
It's an excellent question, and it speaks to why this briefing is so valuable. The answer lies entirely in her methodology. She didn't try to learn the granular legal code of all 50 states.
Which would be impossible.
That would be impossible for an entire law firm, let alone one person. Instead, she asked the parents for the raw inputs and outcomes. She completely bypassed the legal jargon and went straight to the material impact.
Oh, interesting.
Yeah, questions like, how much did you spend? How long have you been in the system? Who holds custody right now? By standardizing the survey questions across the country, she allowed the macro patterns to emerge from the micro chaos of 50 different jurisdictions.
Wow. He basically created a universal translator for family court trauma. So Meg's individual story is the beating heart of this data. It's the engine. But to truly understand what she uncovered, we have to look at the massive scope of the information she collected. We have to dive into the numbers.
Let's look at the national overview, because the sheer volume of data points is what elevates this from, anecdote to empirical evidence.
Right. So she gathered verified data from exactly 1,953 families across all 50 states. And those families represent 1,961 children.
And the most critical metric right at the top of slide 1 is what she categorizes as the stuck status.
Yep.
Out of those 1,953 families, 968 families are currently trapped in the system.
That is almost half.
Exactly. They are actively navigating this right now, today, with zero clear resolution pathway. The briefing notes that even when cases technically close on paper, the families remain fractured, often trapped in post-judgment litigation or endless modification filings.
It sounds suffocating. I mean, imagine being locked in an escape room where the rules change every hour, every hint costs you $1,000, and the timer never actually runs out. That's what this data describes. There's no clear way out.
And that escape room analogy is particularly apt when we look at the metric on slide 5, which Meg brutally but accurately labels time theft.
Time theft, that's a heavy phrase.
It is. The average duration of these cases across the country is 93 months.
93 months. Wait, let's do the math on that. That's almost 8 years. 7.75 years to be exact.
7.75 years. And the median is 21 months, which means even the supposedly faster cases are still dragging on for nearly 2 years minimum.
Good Lord.
But the extremes are terrifying. The data shows 202 families have been trapped for over 10 years. Another 301 families have been in the system between 5 and 10 years.
Over a decade fighting for your kids, I can't even fathom what that does to a person's psyche.
Well, we have to consider the developmental cost to a child here. The briefing explicitly points this out, and it's a critical psychological insight. 7 years is an entire childhood epoch.
Yeah, that's elementary school to high school.
Exactly. It means missed birthdays, missed graduations, missed first dates, missed college decisions. It means children are actively aging while in foster care or in the custody of a hostile, alienating parent. And biologically, psychologically, those parent-child bonding windows close permanently.
You can't get that back.
You don't get those years back just because a judge finally signs a piece of paper a decade later saying case closed. The developmental trauma compounds every single year.
And Meg tracked exactly where this time theft is happening most severely. Instead of just giving us a massive, overwhelming national average, she broke it down. Let me walk you through some of the geographic hotspots she documented, because the depth of the data we've received here allows us to see how this plague mutates from state to state.
The state-by-state breakdown is incredibly revealing because it highlights different symptoms of the same disease.
Right. So let's start with California. They have the highest number of submissions in Meg's database at 164. The average duration there is 71 months. But the most shocking stat from California isn't the time, it's the money.
The financial drain is massive there.
Meg documented an average asset loss of $41.2 million in aggregate just among those 164 families. That averages out to over $250,000 per family. Erased.
Which brings up a crucial macroeconomic reality. If you zoom out, we aren't just talking about personal tragedies here. We are talking about a shadow economy.
The shadow economy.
That is $41 million removed from local California businesses, removed from children's college funds, removed from the housing market, and funneled directly into the legal sector.
Right. So California shows us how the system drains family bank accounts on a massive scale. But what happens when families completely run out of money? What does that look like?
It changes the entire dynamic.
We see the exact result in Florida, which had 93 submissions. The data reveals that 58% of parents in Florida are forced to fight pro se. They have no lawyers left.
Because the money is simply gone.
Exactly. And what about time? If we look at Meg's home state, Kansas, with 114 submissions, Kansas has the absolute longest average case duration in the entire country, 106 months.
Almost 9 years.
Almost 9 years on average, 9 years. And 21 of those families report complete, total loss of access to their children.
Then you look at Pennsylvania with 74 submissions, which highlights yet another symptom, extreme lost wages. Families in Pennsylvania are reporting an average of $422,000 in lost wages per family over the course of these cases.
$500,000 in lost wages, that's insane.
And their cases average 13.5 years in that state. And in Texas, with 115 submissions, 51 of those families are currently trapped in that stuck status today.
These numbers show us exactly where this is happening and for how long. They paint a map of a nationwide crisis. But the data Meg collected also reveals exactly how much this system is extracting from families. You mentioned it a minute ago, this is a shadow economy.
It is a highly efficient financial extraction engine.
Here's where it gets really interesting. And by interesting, I mean absolutely horrifying. Let's break down the aggregate financial harm documented in Meg's sources, because nobody talks about what this actually costs the average middle-class American family. We think of custody battles as something rich celebrities go through, you know?
Right, like a Hollywood divorce.
Yeah, but this is hitting everyday people.
The economic devastation is absolute.
Yeah.
It is total financial ruin for the majority of these families.
Nationally, Meg's data shows the average family is paying $61,308 in attorney fees alone. Over 61 grand, just to try and see their kids, and that's just the lawyers.
There's so many other fees.
Right. Then you have the GALs, the guardians ad litem, or court evaluators. They average $8,344 per family. And you can't forget the court-mandated therapy and reunification costs, which average another $8,804.
When you aggregate those numbers across the nearly 2,000 families in Meg's dataset, you are looking at over $66 million in attorney fees alone.
My God.
But as we saw with the California data, the broader economic destruction is even worse. The briefing documents over $3.1 billion in aggregate asset liquidation nationally.
Billion with a B.
Families are being forced to sell their homes, cash out their 401ks, completely liquidate their life's work and their children's inheritance just to fund the litigation.
And there's this one data point in the financial section of the report that really jumped out at me, and I need you to explain it. Under the lost wages category, the aggregate number Meg compiled is listed in the trillions, $10 trillion. Now, the briefing explicitly notes that this is a data anomaly. Can you explain what that means in this context and why Meg left it in the report?
Yes. It's a fascinating look at the limits of quantitative data. In data science, an anomaly of that size usually happens when respondents are asked to quantify something that feels infinite or fundamentally incalculable to them.
Okay. Make sense of that for me.
Think about it. If a parent had a thriving career, say they were making $80,000 a year, and the court case drags on for 10 years, it causes them to lose their job because they're constantly in court. it destroys their professional reputation, and it permanently alters their earning potential for the rest of their life. How do you put a number on that?
You can't.
Right. Some parents likely entered astronomically high numbers into the survey, billions or trillions, to reflect the absolute, unquantifiable severity of the income destruction they faced. They didn't just lose a week's pay, their entire economic future was annihilated. Meg kept it in because the anomaly reflects the psychological truth of total financial ruin.
Total ruin, which leads directly to the most devastating statistic in this entire financial package. Because of these exorbitant costs, 52.2% of parents are currently fighting pro se.
And for those listening who might not be familiar with the legal term, pro se simply means representing yourself. You are walking into a courtroom without a lawyer.
Right. Over half of these parents are doing it alone. And Meg's data found that 30.9% of them went pro se specifically because they ran out of money, not by choice, by bankruptcy.
If we connect this to the bigger picture, this is the crux of the entire crisis. We are talking about the principal-agent problem on a systemic level.
The principal-agent problem.
Yes. When families are drained of an average of $61,000 in attorney fees, they hit a wall. They are bankrupt. But the state, the opposing wealthy counsel, or the CPS agencies, they have endless taxpayer-funded resources.
Right.
So you have a mother or a father stripped of their assets, emotionally devastated, forced to navigate a complex, highly adversarial legal labyrinth entirely alone.
Right, but I want to dive into that principal-agent problem you just mentioned because I think that explains why this is happening. The agents, the lawyers, the evaluators are supposed to be working for the best interest of the principal, the family, or the child. But their financial incentives are completely backwards.
Precisely. This exposes the underlying incentive structure of the system. Court insiders, attorneys, GALs, court-appointed therapists, they generally bill by the hour. Their financial incentives inherently favor prolonging cases rather than resolving them.
Because more time equals more money.
Exactly. Every continuance, every new motion filed, every mandated therapy session is a billable event. A system that profits from conflict will inherently, organically produce more conflict. If you get paid more the longer people fight, you are not going to design a system that solves the fight quickly.
Okay, so we know the system bankrupts families. We see the financial extraction. But Meg's data goes deeper than just the bank accounts. She didn't just track the money. She exposed the precise, systemic mechanisms used to physically separate children from their parents.
Yes. Slide 8 of the briefing is titled Systematic Patterns: How Corruption Becomes Procedure. Meg's data identifies 9 recurring mechanisms that act as the standard operating procedure for family separation across all 50 states.
Let's break down the top ones, because these are the actual mechanical levers being pulled to destroy these families. We aren't just talking about vague corruption, we are talking about specific tactics. Mechanism number 1, malicious report to automatic removal.
Going to the briefing, a single, often entirely unvetted and uninvestigated allegation can trigger the immediate physical seizure of a child by the state. There is no due process hearing before the separation occurs.
That's wild.
And once the child is taken, the burden of proof is immediately reversed.
Meaning you are guilty until proven innocent.
Exactly. The accused parent must now prove their innocence rather than the state proving their guilt. The data cites a real example where a CPS took children because a mother couldn't locate her prescription medication during a brief home visit. She found the bottle 10 hours later, but CPS had already taken the kids and refused to return them.
That is terrifying. Just poof. Kids are gone over a misplaced bottle. Mechanism number 2 is what Meg calls dual system entanglement. The data shows 779 of these families are fighting both Family Court and CPS simultaneously.
This creates a literal double jeopardy scenario, and it is a bureaucratic nightmare. Family Court and CPS operate under different rules, different statutory jurisdictions, and they often issue entirely conflicting orders.
So what does a parent do?
Parents are forced to navigate 2 separate legal mazes at the same time. You might comply with a CPS order to take a specific parenting class, only to find it violates a family court order regarding your visitation schedule. You're trapped in a catch-22 designed by the state.
Now, mechanism 3 is a big one, and I want to pause here so we can really explain it. Gal-Casa conflicts of interest. Before we look at the data, what exactly is a guardian ad litem, or to GAL? On paper, what is their job description versus what this data says they are actually doing?
On paper, a guardian ad litem is a court-appointed representative. Their sole job is supposed to be objectively investigating the family dynamic and advocating for the best interest of the child. They are supposed to be the neutral voice in the room.
Okay, but Meg's data reveals a very different reality.
A completely contradictory reality. The data shows that these supposed objective child advocates are often deeply entrenched in the same courthouse networks as the judges and opposing attorneys. They work in the same complexes. They attend the same social events.
Wow.
And because they charge thousands of dollars per case, often demanding $4,000 to $10,000 up front as a retainer, their financial alignment is implicitly with the court insiders who assign them the lucrative cases, not the children they are appointed to protect.
That makes total sense. Follow the money.
They have a massive financial incentive to extend the litigation and side with whichever party can continue paying their hourly rate.
It's unbelievable. And the fourth mechanism is what parents in the survey call impossible reunification requirements.
This is where the system sets a parent up to fail on purpose. Courts will order a parent to work full-time to pay exorbitant child support, while simultaneously mandating they attend expensive, out-of-pocket therapy sessions during normal work hours.
Wait, during work hours?
Yes, and pay for supervised visitation that can cost thousands of dollars a month.
Right, so if you go to work, you miss the therapy. If you go to therapy, you get fired. If you pay for the visits, you can't pay the child support.
Exactly. If a parent cannot afford all three simultaneously, or if their work schedule conflicts with the rigid visitation schedule, the court officially deems them non-compliant. Any failure to achieve the mathematically impossible is officially recorded in the court docket as evidence that the parent is unfit.
And all of these mechanisms, the removals, the dual systems, the conflicted GALs, the impossible requirement, they're all fueled by one primary weapon. This is the part of Meg's data that truly blew my mind. The engine driving this entire machine is false accusations. 37.1% of all separations documented in this 50-state briefing are initiated by false accusations.
The breakdown Meg provides on this is highly specific. Out of the total, 496 families report that false accusations of domestic violence, physical abuse, or parental alienation were used as a weapon within family court. Another 228 families report malicious CPS reports filed by vengeful ex-partners.
But wait, I have to stop you there. I have to play devil's advocate. If someone makes a provably false accusation that destroys a family, shouldn't there be a massive legal consequence? What about perjury? What about filing a false police report? Why does Meg's data suggest the system just accepts these documents without any consequence for the liar?
Because you're looking at it through the lens of criminal law, where perjury is a crime. In the reality of family court, as heavily documented by these 1,953 families, there is a profound structural blind spot. The system is designed to err on the side of caution.
Meaning what, exactly?
Meaning judges are terrified of leaving a child in a potentially dangerous situation. If a judge ignores an allegation and a child gets hurt, that judge is on the evening news.
Oh, their career is over.
Exactly.
No.
So their incentive is to rubber stamp the removal immediately, ask questions later, and let the slow bureaucratic process sort out the truth. The problem is, malicious actors, vengeful ex-spouses, high-conflict personalities, they know this. They exploit this safety mechanism.
That is so twisted.
If you want to gain the upper hand in a custody battle, the data suggests that launching a false accusation is highly effective, gets the other parent removed immediately, and carries almost zero risk of penalty because the judge will just wave it away as erring on the side of caution, even when it's proven false years later.
It weaponizes the system's own safety protocols against innocent parents. And to truly grasp the weight of these mechanisms, to understand the devastation of these false accusations, Meg didn't just rely on bar charts and spreadsheets. She ensured that the voices of the parents themselves were the primary evidence. She collected their actual, unvarnished testimonies.
And this is where the intelligence briefing shifts from quantitative data to qualitative reality. This is the human cost of the machinery we just described.
I want to read some of these testimonies directly to you, because Meg collected absolute heartbreaks, and we owe it to these families to hear them. Let's look at Sabrina's testimony. Her quote is long, and it is gut-wrenching. Sabrina passed every single test the state threw at her. Therapy, drug tests. She points out she never even did drugs to begin with, psychological evaluations. She did everything the court asked.
And the result of that, total compliance.
The judge terminated her rights to her oldest son anyway. And Sabrina says the corrupt judge laughed in her face and told her that no matter what she did, no matter how many hoops she jumped through, she would never be a good enough mother in the eyes of the state. Her oldest son was adopted out to strangers. She doesn't even know if he's alive or dead.
The sibling bond is completely severed by the state.
Yes. She writes that she has to show her remaining kids pictures of their siblings just so they know they exist. She has to grieve them like they are dead, even though they are out there somewhere living another life.
We also have a testimony from an anonymous parent in Texas documenting something called extrinsic fraud.
Wait, before we get into the story, what is extrinsic fraud? Because that sounds like a very specific legal mechanism.
It is. Extrinsic fraud occurs when one party uses deceptive tactics outside of the actual trial to prevent the other party from getting a fair hearing. For example, hiding evidence, bribing a witness, or in this case, tricking someone into signing a binding legal document under false pretenses.
Okay, so with that context, what happened to this family in Texas?
Their kids were initially removed over a misplaced prescription bottle that was found 10 hours later, the case we mentioned earlier. The kids were temporarily placed with a paternal uncle. Years later, that uncle and his wife utilized extrinsic fraud. They tricked the parents, threatened, pressured, and coerced them into signing a document that severed their visitation rights entirely, convincing the parents it was just a temporary custody update.
The parent wrote in Meg's survey, "They have intentionally and quite literally ruined all four of our lives. They've forced them into a hardcore emotional and psychological hell where my girls are being silenced. The mental health trauma inflicted on those two little girls is irreparable, all because of a fraudulent signature."
Then there's Sierra from Kansas. She specifically names her judge, Judge Montevi. Sierra writes, "Judge Montevi awarded custody to someone who had no witnesses when I had 5 witnesses saying he smoked marijuana with my kids in the room and abused me and the children."
But hang on, I have to jump in here. Why would a judge intentionally give a kid to a known abuser? I mean, 5 witnesses to 0. Is it actual malice on the judge's part, or are these judges just overwhelmed with massive caseloads and relying on bad reports from those conflicted GALs we talked about?
According to the data Meg collected, it's often a toxic combination of both. Judges are absolutely overwhelmed with caseloads, which means they outsource the investigation to the GALs. But if the GAL is financially conflicted or biased, the report the judge reads is already tainted.
Oh, I see.
Furthermore, the data suggests a systemic bias where protective mothers who report abuse are often viewed as hysterical or alienating, while the accused abuser is viewed as the victim of a smear campaign. The system actively punishes the parent trying to protect the child.
And we see exactly that in Haley's story from Washington State. CPS took her kids for 10 months because her kids actually spoke up about being abused by their other parent. CPS claimed Haley coached the kids to say it.
Despite the fact that Haley provided hospital records and protective orders from another judge proving the abuse had occurred, the system ignored hard medical evidence and chose to punish the protective parent and the children for speaking out.
Exactly. And finally, Elizabeth from Arizona. She had an abusive ex with narcissistic personality disorder. She says corrupt CPS and family court completely ignored the court interviewer, ignored the kids' teachers, and ignored the kids themselves. The system gave complete coercive control to her abusive ex. It cost them all their assets, everything she and her kids worked for, and even the life of a family pet.
If we synthesize these voices, a very dark, undeniable common thread emerges from Meg's research. Across 50 different states, parents report profound shock at the total absence of due process. They report permanent, multi-generational trauma. They universally state that the children suffer the most dropping grades, suicidal ideation, severe attachment breaks.
The kids are literally collateral damage in a profit machine.
And we must remember to look at this impartially, based only on the sources provided by these families. According to this data, the system repeatedly acts as a weapon for abusers rather than a shield for the vulnerable. It empowers coercive control rather than preventing it.
So what does this all mean? We've looked at the financial ruin, the mechanisms of separation, the heartbreak in these testimonies. With all this trauma, all this litigation, all these millions of dollars spent, what are the actual outcomes for these children? Meg tracked that too. Let's look at slide 4, custody outcomes. This is the real verdict of the system.
The statistical reality here absolutely shatters the common public perception of family court. Most people assume that 50-50 joint custody, an equal, fair split between two capable parents, is the default outcome of a modern custody dispute.
It's not. It's not even close. Out of 1,953 families, only 11.7%, just 229 families, received 50-50 joint custody, 11.7%.
The largest segment on Meg's chart is what she labels lost access. 40.3% of the families in this database, 787 families, lost primary or all access to their children. That combines parents severely reduced to visitation only and those suffering no contact or total loss.
And it gets darker. 26.8% of these families either had their children placed in state foster care or had their parental rights permanently terminated and the children adopted out. Over a quarter of these families were permanently destroyed by the state.
This raises an important question. We have to look at the philosophical core of these institutions. If the stated legislative goal of family courts, and if the absolute mandate of Child Protective Services is family preservation and the best interest of the child, why does Meg's data prove that permanent separation, severe restriction, and total loss of access is the overwhelming default outcome?
It's a complete paradox.
The results are diametrically opposed to the stated mission.
It's a machine that produces orphans out of children who have loving, capable parents. But here's the pivot. Here is why Meg is an absolute force of nature. She didn't just expose this nightmare. She didn't just sit in the ashes of her own life and the lives of 1,953 other families and say, look how terrible this is. She built a blueprint to fix it.
She shifted from diagnostics to engineering a massive, actionable solution. She read through every single one of those 1,953 submissions, absorbed all of that trauma, and distilled it into a highly structured, parent-driven reform agenda.
She came up with 8 non-negotiable reforms. And we are not just going to list these off. We are going to detail these 8 demands and explore exactly how they would change the system, because this is the roadmap out of the escape room. Let's look at the first demand she laid out.
Demand 1 due process restoration. Parents demand that no child can be removed without a judicial hearing before the separation occurs.
Right, because right now, as we saw, they just take the kids on an anonymous tip.
Exactly. Meg's reform demands a probable cause hearing within 72 hours, shifting the burden of proof back to the state where it belongs constitutionally. The state must prove the child is in imminent danger before traumatizing them with a removal, rather than removing them and making the parent prove they are safe.
It's just basic constitutional rights applied to family law. Demand 2 false accusation accountability. We talked about how the system currently has a blind spot for perjury. Meg's reform says if you file a malicious, provably false report to destroy your ex, you should face perjury or fraud charges. Period.
This changes the entire risk-reward calculus for high-conflict individuals. If launching a false accusation carries the risk of jail time, the weaponization of the system drops dramatically.
Demand 3 strikes right at the heart of that principal agent problem we discussed. Eliminate financial incentives. The parents demand an end to hourly billing for GALs and court-appointed therapists.
Let's really think about how this changes human behavior. If a GAL is paid a flat fee for an evaluation, regardless of how long the case takes, their financial incentive is to conduct a thorough investigation and close the case efficiently.
That makes total sense.
By demanding a move to flat fee or outcomes-based compensation, Meg's reform removes the financial incentive for endless case continuances.
Demand 4 a mandatory appeals pathway. Right now, family court decisions are basically treated as final because appealing them is too expensive, and the appellate courts rarely want to touch family law. Meg's blueprint demands state-funded appeals counsel and appellate courts empowered to actually overturn corrupt family court rulings.
Demand 5 eliminate dual system entanglement. One family, one system. CPS and family court should not operate simultaneously, creating that double jeopardy we discussed earlier where parents are forced to follow conflicting orders.
Demand 6GL and CASA independence. This is crucial for fixing the corruption. Meg demands mandatory recusal if a GAL has a personal or financial relationship with the judge. You can't have the people evaluating the kids playing golf on the weekends with the judge who is making the ruling. It's an inherent conflict of interest.
Demand 7 focuses on the absolute permanence of the state's actions. Extraordinary evidence for rights termination. Parental rights should only be terminated with clear, convincing, and extraordinary evidence of severe, irremediable abuse. It cannot be based on circumstantial evidence, hearsay, or a failure to pay a court-mandated fee.
Right, like being broke shouldn't cost you your kids.
Exactly. And crucially, there must be a restoration pathway post-termination if circumstances change.
And finally, demand 8 investigative accuracy standards for CPS. CPS must be mandated to investigate the reporter of the abuse, not just the accused parent. If a report is proven false, it needs to be permanently documented on the record, and the reporter must face consequences.
But Meg didn't stop at just listing demands. A list of demands is just a wish list without a mechanism for delivery. She operationalized this intelligence.
This is the logistical feat that absolutely blows my mind. Meg looked at this massive data set and realized that states with 30 or more submissions had enough critical mass to expose highly localized patterns of corruption. So for states like California, Texas, Kansas, Florida, Ohio, Pennsylvania, 10 states in total met this threshold. She created custom, ready-to-download PDF state packets.
And she made them freely available on standwithmeg.com. She democratized the intelligence.
If you are listening to this right now and you live in one of those states, I want you to understand what Meg has provided for you. These packets aren't just generic flyers complaining about the system. They contain local data specific to your state. They name specific judges who are repeatedly flagged in the data.
Real accountability.
Yes. They name specific attorneys and GALs. They highlight the top allegations used in your jurisdiction, the exact average financial harm in your state, and reform recommendations tailored to your state's specific legislative issues.
It is actionable, localized intelligence. Furthermore, she lays out a concrete 30-day and a 90-day escalation plan for parents to use these packets. The immediate 30-day actions involve downloading the packet, cross-referencing your judge's history, and connecting with local support networks so you aren't fighting alone.
And the 90-day plan. Taking these packets directly to your state legislators, handing them the data, drafting state-specific reform bills based on the 8 demands, partnering with investigative media, petitioning for inspector general investigations into these specific family courts. Meg took her own total isolation, the deafening silence forced upon her when the state took her 5 kids, and she built an entire machine to ensure that no one else ever have to fight alone again. She organized the evidence for them.
Because knowledge, in a system that relies entirely on obfuscation and secrecy, is the only defense. What Meg has built is not just a support group. It is an incredible, highly structured tool for civic transparency and accountability.
And this brings us to why you, listening right now, need to care about this. Even if you have never set foot in a family court, even if your marriage is perfect, even if CPS has never knocked on your door, Meg's data reveals a terrifying reality about the civic structure of the country we live in. There is a bureaucratic, highly profitable machine operating in every single state, entirely in the shadows.
Everywhere.
A machine capable of legally removing children based on completely unvetted allegations. A machine capable of draining a family's entire life savings, their 401k, their home equity, without a shred of constitutional due process. It is happening to your neighbors right now.
It is a profound vulnerability in our civic structure, and it thrives because the general public assumes the system works as intended.
It does. And I want to leave you with a final thought to mull over, something to really explore on your own. We talked at the beginning about how a normal board game has rules, but this system is a game where the rules constantly change and the referee is corrupt. Well, Meg waded into that rigged game and pulled out the actual rule book. So ask yourself this. If Meg, a single mother in Kansas, stripped of her 5 children, stripped of her resources, grieving the unimaginable loss of her family.
Her entire world.
Right. If she could single-handedly compile a 50-state intelligence briefing that exposes trillions in economic damage and thousands of constitutional violations, what does it say about our state oversight committees, our attorneys general, and our elected officials who have allowed this system to operate in the dark for decades?
That is the ultimate question. If one citizen can find the data, why hasn't the government?
The muddy water, the confusion, the isolation, none of it was an accident. It was by design. And Meg just turned on the floodlights.